All right, good morning, everyone. Welcome to the first session of our webinar series on the legal foundations and strategic structuring of lease financing, produced by the California Debt and Investment Advisory Commission. In our first session today, we intend to explore the structure of lease financing, legal precedents, conventions, and misconceptions. I'm Robert Berry. I'm the executive director here at CDIAC. Financing leases have been a consistently utilized tool in California public finance for the past 50 to 60 years. These structures are particularly useful when local public agencies need to borrow money and are confronted with the almost insurmountable hurdle presented by the California Constitution's prohibition of incurring indebtedness in excess of an agency's income and revenue for the fiscal year without two-thirds voter approval. Through a series of cases, the California Supreme Court created an exception for long-term financing that is repaid through rental payments on a leased asset. Commonly known as the lease exception to the debt limit of the California Constitution, the validity of lease financing is based on several important legal principles that cause the financing structure to walk and quack like a lease. The critical elements of financing leases, which will be discussed in this series: the rent obligation is contingent upon and is paid in exchange for beneficial use and occupancy of the leased asset. There's a provision for rent abatement if the use and occupancy of the leased asset is not maintained, and rental payments cannot exceed fair rental value. These elements form the foundation of what we have called the lease construct under the lease exception to the Constitution. The challenge is how to finance your project with all the practical and circumstantial considerations that you face while staying committed to the lease construct. Next, please. This graph is compiled from CDIAC's debt database, and it illustrates the consistent use of leases in California local public finance since CDIAC began collecting debt issuance data. As a percentage of all local debt issuance, the use of lease financing, that green slice, has narrowed somewhat, especially in the years following the passage of Proposition 39 in the year 2000. K-14 schools had the ability to issue general obligation debt, which presented a better financing option because of the lower voter threshold for approval, but also because of the opportunity to raise the tax revenue to service the debt. Leveraging their limited resources of the general fund was not required, provided they had the 55% vote threshold and could obtain that. The better alternative for K-14 segment explains some of the narrowing, but more recent narrowing is likely attributed to the decline in general fund revenues that cities and counties, the primary issuers of lease financing, have available to service lease debt. However, even with the narrowing, lease financing has represented 7 to 9% of the total principal issued by California local governments since the Great Recession of 2008. It has been a consistently used tool and particularly useful to agencies that have important projects, as I mentioned, where the general obligation debt is impractical. Next slide, please. So to provide some general context for this series, I've included this slide, which portrays a simplified schematic of a very typical lease financing, actually the most common, the leaseback structure. As pictured, the agency identifies an owned asset that can be leased. The agency leases the asset to a finance entity, usually a captive joint powers authority, in exchange for a lump sum lease payment derived from the sale of bonds or the issuance of certificates to investors by the JPA. The lump sum or bond proceeds are used by the agency for the project. Simultaneously, the agency subleases the asset back from the JPA in exchange for rental payments that are used by the JPA to service the debt. I recognize that there are structures not portrayed here where the asset under construction is the leased asset. This direct lease structure relies on elements born of the same legal principles, however. So next slide. Also, to support your understanding of the fundamental aspects of lease financing, I want to draw your attention to CDIAC's Lease Financing Content Series. Available in our publications library and also linked to the event page for this program, we have 3 publications that cover the elements that will be discussed during our series, from the legal fundamentals to the decision points to the recommended practices. It's important to point out that CDIAC and the numerous contributors to our content series on lease financing were motivated to produce these publications not only to update work that CDIAC had produced in the early 90s, but also really as a business continuity measure to facilitate this generational transition that is occurring in public finance. Our presenters today and next week are very experienced and recognize that practices, approaches, and markets have changed over the years, and a fresh view of even the frequently used tools is needed to make sure the next generation of public finance officials are prepared for the challenges ahead. So the next slide, please. So that brings us to our objective for today's installment in our series. So building from the concepts discussed in our written content series, which I just outlined, we'll more closely examine the law and learn more about how the law and financing conventions have influenced how leases are structured today. First, our presenters will discuss the origins of lease financing, the case law, and the resulting legal principles that underpin what we call the lease construct. Then our presenters will explore key structural elements that are considered compulsory elements necessary to establish and maintain a legally valid lease finance consistent with the lease construct. Then lastly, in this session, our presenters will examine structural elements of financing leases that are born of conventions and misconceptions, not necessarily legal necessity, and that should provoke some thoughtful consideration among issuers. This is where the practices, approaches, and markets have evolved. In our next session on the 21st, next week, our presenters will have a very practical discussion about how these financing decisions unfold for issuers and how the market may or may not react. Today's discussion will really set the stage for next week as well. So our goal with this series is to help you execute a financing with greater efficiency, some additional risk mitigation, and perhaps achieve some cost savings together that will increase the value of your lease financing transactions. So before I introduce our faculty team and we get started for today, allow me to quickly run down our standard webinar housekeeping items. So the slides and links to our content series, our three publications, are posted to the event page on CDIAC's website, and it's accessible from the front page of our website or at the link on the screen. Questions during the program are submitted through the Slido application on the Q&A tab. Now, if you don't see the Slido app come up on your screen when you click on that Q&A tab, there is a link in the chat that will allow you to access the program. Sometimes it depends on how you access through the web or through the application, whether you're going to see that. So take a look there if you don't see the Slido app. You may submit questions at any time during the program, and I'll pose them to our presenters during our Q&A period. If you would like captioning, there's a captioning button in the lower left of the screen. If you participate in 70% of the webinar, we'll send a certificate of participation in a couple of weeks. Also, in about 2 weeks, we'll make a full replay of the program available in CDIAC's education portal. Excuse me. And then lastly, visit WebEx's Help Center at the link on the screen if you have any technical problems. Next slide. Now I'd like to welcome and introduce our three distinguished faculty presenters. First, we have Dan Deaton, partner with Nixon Peabody. Dan is in the public finance group of Nixon Peabody, where he represents governmental agencies, nonprofits, underwriters, and others as bond disclosure and underwriters counsel in a wide variety of public finance transactions. Dan is an advisor to the GFOA Debt Committee and has been a frequent presenter for CDIAC and was a major contributor to CDIAC's lease financing content series. Next, I'll welcome John Palmer, partner with Orrick, Harrington, and Sutcliffe, and a new member of the CDIAC faculty team. John is in Orrick's San Francisco office, where he focuses on financing for cities, counties, and community college districts and school districts. His practice includes serving as bond and disclosure counsel on revenue and tax-supported bond transactions in a variety of financing structures. Then rounding out our team for this morning, we welcome David Broadsley, Managing Director at K&N Public Finance. David is a registered municipal advisor who has served cities, counties, special districts, state agencies, and school districts in California over the past 28 years. Prior to his time with K&N, David's experience includes a dozen years in public finance with the city of Los Angeles, where he created the city's leasing corporation. David has also been a regular presenter with CDIAC and a very large contributor to our lease financing content series as well. Thank you all for being here this morning. David, I believe you'll get us started.
If I remember to turn on my video and my microphone. Hi, everybody. My job here is to kind of go over the deep history of lease financing. And for me, deep history goes way back in time. Leases are not a new instrument. In fact, they go back to the beginning of recorded business history. Clay tablets from Sumer have been found discussing leases. Hammurabi's Code has discussion on how to regulate disputes on leases. Continuing to, more modern eras, the Greek and Roman law, leases were discussed in that. In Rome, public property, if it were going to be sold, required a vote of the Roman Senate, but leasing a property was a magisterial activity. So at least as far going back as far as the Romans, leases were used to deal with difficulties in real estate law by public agencies. Medieval period is really interesting to me. The church had decreed interest as being prohibited under Christian law, citing Aristotle and Deuteronomy and Luke. And that caused a great deal of problem in commerce in the Middle Ages. And so over the years, various canon lawyers worked out a scheme in which those prohibitions on the charging of interest could be avoided through the lease instrument. Um, Clearly, the precursor of what we're going to be talking about all during the day. Um, Fast forward a little bit, English common law develops and all the terms that we think about leases, how long they last, the quiet enjoyment, the remedies for default, the landlord's retained reversion at the end of the lease term, and most important to us, the rent as consideration for current use. All of those were developed in common law and then became incorporated in the United States civil law, including California civil law. And then we're going to come to like the modern period, the period that's really most relevant to us, which is California history, beginning about the middle of the 19th century, and a series of defaults, constitutional limits on debt to prevent defaults, and then the various workarounds that the courts allowed local government to do to keep the wheels running. Next slide. Okay, so 19th century, huge growth, lots of stuff going on. Early part of the century, states were building canals, selling bonds to finance those canals. And when tough times hit, particularly the Panic of 1837, states were defaulting on their bonds. And so throughout the country, state constitutions were being amended to put prohibitions, restrictions, I should say, on how the state could issue bonds. Um, next big wave of expansion, the railroad became the transportation mode du jour. And cities were the ones who were financing the expansion of railroad lines to their communities, knowing that the railroad line would guarantee prosperity and provide all the resources necessary to pay back the bonds. Boom, another financial crisis, Panic of 1873, lots of defaults on municipal bonds. And throughout the country, local government debt was becoming restricted by adding debt limits, debt prohibitions to state constitutions. California was very much in that mode. And the first state constitution had a debt limit on state debt, and the second state constitution, I think it's 1978, 1878, added a debt limit to the state constitution, and the critical feature of California's is the two-third voter requirement. That is very rare. There maybe was a one or two other states in the country that set the bar so high for municipal debt. The drafters of that constitution were very, very debt adverse, favored pay-as-you-go financing, and so put a high barrier to the approval of GO debt. Well, the best intentions then meet reality. California is completely growing, tons of needs for public infrastructure. This restriction was really preventing California from doing what it had to do. And people were looking for alternative ways to accomplish public goals. Um, One of those ways made its way to the Supreme Court. It was McBean versus the city of Fresno. This was a contract for waste disposal. I think they call it a sewage farm where they hauled off the stuff and put it on dirt. And it was a long-term contract. I think it was 5 years. Went to court. The court said that this is not debt. This is something else. This is a payment for use. This is payment for services. It is a contingent obligation and not therefore long-term indebtedness. Uh, that was a key decision in sort of creating uh, um, a feature of municipal law. Let's go to the next slide.
David, right before the next slide, though, the couple point to raise there is, there is a good reason for having a debt limit, right? And I think that for that regulates local agencies, that's different than, for example, corporations. And the principle undergirding a lot of this is making sure that current tax revenues are applied to current services, and that you don't end up in a situation where you end up with this generational inequity problem of people ending up, paying their taxes with respect to something that happened in a bygone era. And so, from a policy perspective, a lot of this is trying to keep current revenues with current services and making sure that people are getting the services they're paying taxes for. And so there's a good policy undergirding with this. But as you point out with McBean, that you end up with an immediate practical problem with an absolute application of that principle, because then it actually inhibits your ability to provide the current services that you're supposed to do, because that's just not an economically feasible way. But to that end, I think it's important to understand that the so-called debt limit is not a debt limit. It is a far broader concept than a debt limit. It prohibits counties and cities and school districts from incurring any indebtedness or liability in any manner for any purpose exceeding in any year the income and revenue produced in such year. So understanding that it's not just incurring debt, it's incurring any liability for any purpose. And so I think what we end up with is, I think to your point about the 2/3 voter supermajority, the text of the Constitution doesn't comport with practical reality. If it ever did, even in 1879, very quickly, it loses its ability to work in practical reality. And so we have, if you look at even in the McBean uh, case, it's hard to argue that they have not incurred a liability for any purpose in a future fiscal year. And you see the Supreme Court already trying to reckon with the words can't actually mean what they say. Um, Otherwise, the constraint on local agencies is too much. Anyways, just
Um,
a couple points on that slide.
Yeah, the debt limit as aspiration, not absolute, and we'll see this. We won't cover special fund exceptions to the debt limit, the whole broad thing of obligations imposed by law, whatever that means. But certainly pension obligations, where in most communities, you are using your tax revenues to pay the pension associated with services um, provided long ago. But it's that balancing act that the courts have been trying to, um, to find the space between, lofty goals and the reality of needs of keeping, the machine running. And the other thing, Dan, is that, municipalities don't go away. Corporations can go away, in a bankruptcy. Municipalities are gonna be there. So, there's a lot of differences between how you manage the obligations of a municipality.
And I think that those are both
Municipalities can tell people. Oh, sorry.
that we're gonna
Before it's done.
sort of pick up on later, both sort of the pitfalls of importing corporate concepts into municipal deals, and also the problem in having the Supreme Court act as intermediary between the legislature and reality. So more to come on both those topics.
Yeah, maybe the problem or the gift, but let's, move to the next slide. Okay, so we get to now where leases really become features of California law, and there's 2 cases, the Offner case, where it was a lease agreement for an incinerator. There were various options to purchase over the term of the lease, but, it was the options to purchase were at fair market value. And then there was about 8 years later, a case went to the Supreme Court from the state, Dean versus Kukul. The state has its own debt limit, but the concepts are really similar. And in that case, what the court was presented was um, a lease where at the end of the term, the asset automatically vested in the lessee. It was a lease purchase. very similar to an installment purchase contract. And both these cases, the courts found these arrangements to be legal, and we were given the Offner-Dean rule, which some of you probably have heard before, which established the notion of municipal leasing as being something that's accepted from the state constitution. Um, Robert already mentioned sort of the principles of that. One thing I found interesting, I hadn't gone back and read these cases like for decades, maybe, and they're very short. It's actually I recommend it to anybody who's nerdy enough to care. And there apparently were 300 nerds signed up for this webinar. The word abatement isn't used anywhere in these cases. The provisions for abatement were in the contracts and continue to be in contracts, but it never was a word that was used explicitly by the courts until much later decisions. And then we go on to the sort of
Just to-
using these tools. Oh, go ahead,
just-
Ron. Dan.
Yeah, just to kind of emphasize this, when we look at something that is 80 years old, we can treat it as like written in stone. And we shouldn't ever do that with a case like this, but rather realize the practical realities the court was really actually dealing with here. I can't stress that this is not what the explicit text of the Constitution says. But the Supreme Court is wrestling with the fact that the explicit text doesn't work. It's not it's not operator. And as John basically pointed out, the Supreme Court is serving as an intermediary to figure out what are the appropriate boundaries of the debt limit. And in doing so, and this pops a lot of people's bubbles who don't understand sort of what courts actually do. The California Supreme Court is serving a policy role. It's not serving it's not trying to, in essence, think deep thoughts about what words in the Constitution actually say. It's clear by the time you get to these two cases that the Supreme Court has looked up and sized up the actual words within the debt limit and determined as a policy matter that can't apply to local agencies. And though they are starting to craft a policy boundary within which liabilities and obligations can extend out of a current fiscal year because they need to. Otherwise, it just doesn't operate within the economy.
Yeah, and we're talking post World War II, tremendous boom in California, just extraordinary capital needs with all this population showing up, and the need to get things done. And I've never been able to get my hands on a whole lot more information that's not in the opinions about these business transactions, what they look like. I don't know how common these were in terms of what was going on elsewhere, but presumably these were the financing itself was arranged by the developer, and they use these rental payments to service their loans, which brings us to the 1960s, where the idea of something that looks like a lease revenue bond comes to be. And we can go to the next slide for that. So 1962, Dorther Chandler Pavilion, the music center in downtown LA, went to the voters for a geo vote, got a simple majority approval, but that wasn't good enough to issue the bonds. And as the forces came to shove, there was developed an alternative form of financing, lease financing, that would secure loans that would be placed with private investors. They weren't quite bonds as we know them, but it was a loan cut up into pieces for investment, and they got a private IRS letter ruling that the interest component on the lease payments were tax exempt. And this is like a magic moment to me. It's like when the god Janus emerges with both faces, and one direction is the debt limit, and this is not debt because we've decided under California this isn't debt. On the other hand, this is a municipal debt and therefore benefits from tax exemption and municipal debt. On the razor's edge came this transaction, and this is really the transaction that gets the ball really rolling. The next year, the IRS releases a letter ruling that's not private. It's generally available that nonprofit corporation bonds issued on behalf of governments could be tax exempt under certain circumstances. One of the key circumstances was that at the end of the lease, the leased asset becomes public property. I don't know what was going on then. I was I was personally more concerned with getting to Disneyland than understanding the rules of public finance. But there must have been stuff going on for the IRS to think it would be appropriate to issue a general rule and not just these private letter rulings. 1964, we get to Anaheim's baseball stadium, financed through lease revenue debt. And in this case, they obtained a ruling from the controller of the currency that these obligations were eligible investments for national banks, and up to 10% of a bank's assets could be invested in these kinds of municipal obligations. So this took what was a somewhat limited tool, limited to what a handful of investors were being assembled, to a tool that had much broader access to the capital markets. 1965, we move away from the nonprofit corporation to a joint powers authority. This is the Anaheim Convention Center. The switch to the JPA was because at some point it was determined, probably by some assessor somewhere, that these are leases of government property. Leases of government property are subject to possessory interest taxes. And suddenly this new cost, if you will, these financings emerged. And to address that, the ownership, or the nominal ownership, the nominal party that is involved in the leasing of this public property became another governmental agency, which was then statutorily exempt itself from property taxes. And then we get to 1966, huge transition. San Diego Stadium, bonds were sold to the public market. The first real lease revenue municipal bonds. They had to seek because now we have road securities. It's subject to the federal securities laws. And the question was, municipal bonds didn't require registration. Do these require registration? And at that point, they had it was the practice, and you would have to go to get a no action letter from the SEC that this was not subject to registration. But the key thing here, now you had a liquid investment. You had a secondary market that could develop, and liquidity leads to lower interest rates. So key transition. Later that year, a nonprofit financing for Orange County. It was also sold at competitive bid, and I just realized I misstated. The San Diego Stadium didn't need a no action letter because it was a government agency. It was a JPA, but then it went to the nonprofit. The nonprofit needed a no action letter to clarify that the nonprofit was not subject to registration. And this whole thing of marrying the rules of securities and federal tax law, and then the local law and its exceptions, really was an art that this real juggling act that folks working on these deals were able to assemble these novel forms of finance.
David, I think it's important to put the 60s into context in a couple of respects, right? It can't be ignored that 1962, as the first lease revenue bond, follows 2 years after the Supreme Court's decision in Redondo Beach, which had actually struck down a series of bonds that effectively would have been payable from tax streams that came from the general fund, effectively. And so you can see, even by the late 50s, you have cities that are needing to be able to borrow against their general fund and coming up against the debt limit and trying to find ways to get around it. The approach in Redondo Beach is struck down in 1960. And then you get to 1962 for other statutory changes. None of these things become court tested, right? None of these various transactions that you see here work their way through the courts. These are all practitioners that are developing these kinds of approaches. But when you hit the 1960s, you're also talking about an increased need for major public projects to be using the general fund as credit to provide things over a long term. And you can see the things that it's being used for here. But you also don't have this massive wide scale indebtedness going on by local agencies because we're before Proposition 13, right? And so you might want to talk a little bit about what the impact of Proposition 13 has and why all of a sudden debt explodes at some point.
Yeah.
1960s is very discrete, right?
Yeah, it's interesting. Actually, you mentioned I hadn't even thought about this. Look at the projects, stadiums, convention centers, music centers, no courts, no police stations. These key things were these kind of quasi-public private projects that, and I don't know what the reason for that, but I'm struck by that. But let's move into the 70s.
David's favorite decade. Right?
It is. It is. The 70s I remember mostly. 1978, Proposition 13, huge tidal wave event. Assessments were rolled back to lower levels, but most significantly, the tax rate, which averaged around 2.5% when you added up all the overlapping tax entities, was slashed to 1%, 60% reduction in revenues to local government. The state stepped in using surpluses to bail out local government to help ease the transition, but it was cataclysmic. I happened to graduate from college in 1978 with a burning desire to work for local government and succeeded with my first job out of college being the Santa Claus at a department store, making my Jewish mother very proud and very aware of the importance of her investment in my tuition. But took me 2 years to find my way back to government because government wasn't hiring. Government was a disaster. And that complete now lack of resources, but still the need to get things done, um, really exploded lease financing, but with the lease revenue bonds becoming more common and a new instrument showing up on the scene, the certificate of participation. This is another invented instrument. It's not a bond, but it's an interest in a flow of payments. It walks like a bond, it talks like a bond, but it had a different name and therefore was exempt from bond law. And at that point in time, there was an interest rate cap of 8%. And this is when interest rates, my first municipal deal, which was early 1982, was at 14% interest rate. You couldn't do bonds in that environment. This is when the municipal market was starting to gravitate towards negotiated sale. The bond laws all required competitive bid. So again, very clever folks, very clever bankers and lawyers who still needed to pay their mortgages, figured out a way to keep the wheels running and creating an instrument that still got to the same place, relying on the same basic legal principles, but abandoned the word bond. 1985, the state legislature, easy for me to say, the state legislature jumped in to try to deal with some of the tensions with the Marx-Truss Local Bond Pooling Act. Not clear in the title, but it did major revisions to the JPA law, gave JPAs more power, took away some of the restrictions on how you could use them, and made the JPA really the dominant financing entity for lease revenue bonds. And then we chug along doing deals, selling bonds, selling COPs, and we get through the 90s, and late in the 90s, San Diego is working on its new ballpark. There was a gentleman named Mr. Ryder who made a living suing the city and county of San Diego. There's at least 3 Ryder cases I'm aware of that are significant from his activities. He sued against the ballpark deal, and it was a classic lease revenue bond deal as we all know it. And the California Supreme Court looked at it and affirmed that this was indeed consistent with the rules long established by Offner and Dean, and these were valid transactions. As a practitioner, I thought of this as kind of a non-event. It said what I already knew, that this stuff was fine. Otherwise, how could we be doing it for the last 20 years? What I didn't appreciate, and which we're going to hear more about, was how important this case was to really kind of locking down the legal principles, um, and allowing, at least bond lawyers at least to sleep better at night. And with that, Ron, I think I'll just hand it over to you or to John. I think, John, you're going to pick this up, but we're going to talk a lot about how Ryder worked, because that really is the modern age. And as far as I understand, these two other gentlemen weren't in practice at that point in time. And I'm embarrassed to say I at that point had 18 years in public finance. So Grandpa's done, and Dan
He
and
brought
John could
brought
take it
David
over.
out of his dungeon for good reasons, right? So, yeah.
Thanks, David. I think we can skip the next slide and go to the foundation slide.
Oh, I'm sorry. I skipped a slide. Well, and I don't need to go back there. I had a slide that just summarized all that we talked about. And we're going to do it again anyway. So go for it.
Okay. So I think David did a really nice job talking about Offner Dean, but there were a couple of ideas here that I wanted to pick apart a little bit. And the first one was that, as David mentioned, these are short opinions, and sort of the whole concept of how we can do debt and shove it into the lease exception hinges on a few sentences in each opinion and a lot of thinking. And I think that this has led to the practice of lease financing being more of an oral tradition than maybe other areas of public finance law, where it's a lot of the thinking that went into interpreting the few sentences that we have in these short opinions, and turning them into documents that sort of undergirds the concept. And I think that there are some issues that have arisen as a result, because like when we played telephone as a kid or operator as a kid, as we sort of whisper the fundamentals of lease revenue bond law into each other's ears, they tend to morph. And Dan, I don't know if you have sort of any sort of thoughts about this, but it seems that that sort of confused the practice a little bit, and that we haven't done a good job as an industry of being clear about sort of what's absolutely necessary, and what features of these deals sort of hinge on particular practitioners' interpretations of what gets said in Offner and Dean.
Yeah, and I think that as David, the history to this is, I think, very important, as we all three agree about it. I think if you look at the levels of lease revenue bonds that are issued, as Robert said at the outset of this, these would have been that the Supreme Court deciding Offner in 1942 would be making a decision that would lead to a broad expansion of the issuance of debt by local agencies, in the post Prop 13 era, would have been unimaginable to the Supreme Court in 1942. And so it's really important to understand that the Supreme Court is serving this evolving intermediary role that John talks about, and we're drawing from certain expansions that existed really in a prior economic era for good reasons, and we're trying to bring those forward in order to, sort of argue for a further expansion from the debt limit that we think is necessary now. And so it is clearly lease revenue bonds is extending out and beyond Offner. And so what you have, and you saw in the 1962, and but for, I still believe, but for Redondo Beach, you may not have had lease revenue bonds for a lot longer, or for other kinds of purposes, because you end up in a situation where the general funds need to borrow money and their projects need it. And for various statutory changes, this basically goes away from the courts for really for 30 years, for 35 years is really what, as a practical matter, it does. And at least revenue bonds kind of go under the radar there, in that sense. And until you hit Rider, what practitioners understand that they're doing as a practical matter is expanding a prior expansion. That's what they're really effectively doing. And they're and they are following first principles and appropriate. They are constraining the rent that is happening under the leases in accordance with Offner and Dean, to be sure. But it's also very clearly a subterfuge for the general fund to borrow money. It's not something that's all that well disguised. And so what you have in the pre-Rider era, as John and I are talking about, you have very narrow legal principles. But what develops out of that is this sort of like going in a herd approach, that everybody sort of does this in sync, in the belief that the sheer size and fact of it would influence the Supreme Court, and the way that it would work against all these local agencies.
And I think we'll sort of talk a little bit about that in the writer context, but before we get there, I think it sort of highlights an interesting tension in the role of bond counsel. As David mentioned, this role of bond counsel emerged out of the railroad expansion west, when there were these municipal defaults on bonds that had been issued to finance the railroad expansion, and the investors in New York wanted a reputable law firm to opine on the enforceability of the bonds that were being issued. And in that sense, bond counsel was a sort of a conservative rule, that was intended to be a check on the overly greased wheels of the economy. On the other hand, we see bond counsel sort of taking these notions in Offner and Dean and creating an entire market out of it, which is maybe a role more focused on greasing the wheels of the economy than the conservative role that they had initially been asked to play, in the expansion of the railroads. And I think that this sort of tension between the push on bond counsel to innovate and also to be conservative is one that we sort of see cyclically, over the next 150 years, starting in the 1870s. And I think that it's maybe worth just sort of drilling down here on the fact that there were practices that evolved out of Offner and Dean, like a level debt service requirement, static collateral pools, not a lot of flexibility for substitution and release, that don't exist anywhere in the opinions. Like, these were ideas that sort of sprung from bond counsel's heads, and were imbricated in the practice. And as Dan said, everybody sort of hewed to, because they thought that sort of being in the middle of the herd provided them with the most safety. And I think that we'll sort of pick apart in the coming slides how Ryder, with its sort of explicit approval of this structure, allowed us to move away from these sort of rigid rules that don't exist anywhere in the opinions.
Which seems to me, John, there was a line drawn. Practitioners pushed the line out to a point, and then writers said, "Okay, that line's the new starting point." And now we're all pushing the line either further. How far can we get away from the facts of, say, the Ryder lease? and still be comfortable rendering opinions and selling bonds and all that.
That that's right. And I think that we, as a community, need to be thoughtful about that and about how the court works as a policymaker, because I think that we've seen that, just as they're willing to give us some rope, they are also at some point willing to use it to hang us. And so, I think that that sort of presents two questions, both, how do we know as a community when we're getting too aggressive? And also whether it's worthwhile as a community to try to push some of this into actual black letter law so that we're not subject to the vagaries of the court going forward.
But, and it's funny, the other chick, and we're not gonna spend any time on this here, but there is the taxpayer. Ryder is emblematic of those folks like the Howard Jarvis Association, who, once we get too far afield, shows up with a new initiative to put new handcuffs on local government.
Right. I mean, the taxpayer being super important because the taxpayer wants infrastructure. They just don't want to pay for it. And that's
Yeah,
the mandate that we're all trying to serve.
yeah, amen.
But also the reason why there's a debt limit, because one point back to the beginning point would make is that unlike corporations, municipalities get to tell people they have to pay money, right? And so that with that power comes all these other kinds of things that come with it and how you manage that appropriately. So yeah.
So let's move to the next slide and talk a little bit about Ryder. So along comes Ryder, and I think that maybe the most important thing that Ryder does is it says, "Hey, um, we get it. This is we get exactly how this works. We get that the JPA is issuing bonds without voter approval. We get that the city is making all the payments to service the bonds. We get that the JPA is controlled by the city, and none of that stops us from approving it. And I think that their sort of explicit acknowledgement that whether you call this a lease or not, whether you call this a subterfuge or not, um, none of this really matters because cities, counties, um, need to be able to issue non-voter approved debt in order to do what they want. And the court uh, sort of says this explicitly. It says, because of the widespread use of similar financing plans throughout the state, and because any doubt about the validity of these plans could impact the cost of capital for the improvement of public resources, um, we've decided to weigh in and approve. And I think that you hear there more explicitly than usual why the court is wading into this, and that the considerations are entirely practical and not legal. Um,
Yeah, John, on this
yeah.
page, one of the things that I'm struck by is Prop 13 changed one key issue is that before Prop 13, um, you didn't really need a vote of the people to raise property taxes. You had to raise them for geo bonds, but if you did a lease revenue bond and you needed more money, you had local taxing power to raise property taxes. And I have to assume as a matter of policy that was important to the Ryder court was kind of in the background. You're not approving new taxes. The taxes now are limited. Now it is a municipality juggling its own books, living within its means and deciding how to allocate its resources, but no longer are you giving them the power to tax on behalf of this debt. And in my mind, that always was an issue for distinguishing lease revenue bonds from geo bonds, even though when lease revenue bonds were being developed, that wasn't even a fact. But I at this point, after 78, it is a fact. And as a matter of policy, there's a whole nother dimension.
Yeah, and I mean, it might be worth sort of pointing out that the sort of Jarvis fueled mistrust of government has both tied our industry in knots, and I think been generally deleterious to the overall operation of government in California sense. And like we've seen this sort of presumptive mistrust of local government's ability to execute on its duties, you know, pervade our industry. And in each sort of instance that it's done so, I think that we've come with sort of reactionary rules that have made it more difficult for public agencies to do what they're supposed to do.
Yeah, and I think that all of that goes to the point that if Ryder versus City of San Diego were, sort of being decided on the first lease revenue bond that comes in 1962, and you're before Prop 13, you're before, Proposition 218, you're before a lot of these measures that are coming in. Also, keep in mind that by the time you get to when this is being decided, we're back to another economic expansion era. We're at a critical point from the economy in terms of what is being done, the kind of infrastructure demands that are going to be necessary for that. And like John said, all of those factors are clearly present in Ryder versus City of San Diego, that the Supreme Court is intentionally creating the boundaries of this, and so that the facts of it and the timing of it and the economic context and the political context that surround it were ideal for that decision. And so, one of the mistakes that people can make is to see as though that this was some sort of ordained and a necessary ruling. It's not a necessary ruling. And so it goes to John's point of how do you as a bond counsel, but I would argue more importantly, like you as a local agency, knowing like, okay, this is a policy space that has been created by the California Supreme Court for good reasons. How do I manage that space? And I think that I believe you get from Ryder versus City of San Diego, um, probably more so than anything else, is just the court operating under the assumption that it's working with municipalities that are operating in good faith and in a reasonable fashion, trying to do their job and being constrained by their job by these various initiatives that are coming in, and trying to sort of provide a policy space to assist municipalities that are operating in that function and for those purposes. And I think that's crucial.
Yeah, which may not always be the case. And we've seen sort of recently how the US Supreme Court has sort of turned its back on stare decisis. And I think that we can sort of imagine how disruptive that could be, were that attitude toward stare decisis brought to our industry. Um,
Hey, John, I'm not a lawyer. Is Stare Decisis a pop singer?
Yeah, thanks, David. Stare decisis, meaning that once the Supreme Court has decided something, it's going to sort of continue to consider it decided and not sort of revisit it, under the theory that people have sort of built structures relying on that decision, and that overturning it would be incredibly disruptive. Um,
And in any given iteration of the US Supreme Court or the state Supreme Court, they absolutely follow without any sort of hesitation stare decisis with respect to every decision they agree with. So that's actually the real doctrine.
A hundred,
So
100%. Um, so let's maybe go to the next slide, and say, Ryder left us with three really important points. It said your rent has to be for consideration given during the rental period. It said that you the corollary being you can't force somebody to pay rent when there's no consideration. So that's the abatement concept. Rent abates when the lessee doesn't have use and occupancy of the facility. And you can't accelerate the debt. It can't be made due and payable. And rent has to be fair rental value. I think that, what's interesting here is that we got these sort of core principles clearly articulated by the court, but we're not entirely sure what they mean. So we know that we can do stuff, or maybe not what they mean, but how they work. So we sort of come into this period after Ryder where we know that we can do lease revenue bonds. We know that the court has given them the gold star, but the court hasn't told us in Offner, in Dean, or in Ryder, for example, how to calculate fair rental value. And this is, I think, as many of the attendees here know from personal experience, an area of lore, and where, if you get 4 lawyers, you'll get at least 5 or 6 opinions on how to calculate fair rental value. And to me, and Dan and David, please weigh in. But this is adumbrated by the conversation that we've been having about how to treat courts as policymakers, because I think that we need to acknowledge that the winds may not always blow in the same direction, and that we need to come up with ways of calculating fair rental value that give the courts purchase to continue to support this as a structure. And David, I don't know, you have I think strong feelings about how to go about calculating fair rental value, and maybe we could talk about that a little bit.
Oh, sure. I mean, I think there's just I've been struck by the fact that there's such a range of approaches, and a range of sort of discipline relative to the concern, from very casual to very focused. And sometimes it's bond counsel. Often it's the issuer. Um, I've had the experience where an issuer's judgment would have been accepted by the bond counsel, but the issuer didn't have any basis for making judgments of fair rental value, and wanted to get, say, an appraiser on board because they just didn't feel they were competent to make representations. So, I think personally, the gold standard is at one of the 3 major appraisal methodologies: depreciated replacement costs. Appraiser looks at that. The appraiser looks at market values. Appraiser looks at rental income possibilities. Well, government buildings don't really have income possibilities. Government buildings don't have a market, but depreciated replacement costs plus the value of land, to me, is almost unquestionable as a basis. But then you have to turn that number, which would be the value of the facility, into rental value. And I tend to favor looking at commercial capitalization rates as the number. Now, I have discovered over the years that I am becoming increasingly an outlier, the old fogey in the room, and that there is a lot of times just using the insured value of a building is considered sufficient as a benchmark of value. And this is something one could spend a lot of time about. But as you say, John, I don't think I fully appreciated, maybe till very recently, that there is no real guidance here. And there is a lot of discretion the courts give local agencies relative to how they make decisions. And the one thing I guess is that I s- and I would encourage when I work on a lease is that there's some physical record of how the conclusion was made, that the debt service is no greater than fair rental value, however that is made. And whether or not it's to my liking or not, I think having a written record of that would be a really nice thing if you were ever challenged. But so far we haven't been challenged. And when areas of law where we're not challenged, our practices tend to get, I won't say sloppy, but we just don't focus our attention as much on the things that nobody else seems to care about.
Yeah, and a couple things I just want to kind of highlight on the topic, just kind of nuts and bolts issues. So, there wasn't an ability for, it wouldn't have been possible for who have provided guidance on fair rental values for a very simple reason. And it's a factual question. It's not a legal question. That's why you see the three Supreme Courts that we have on this are citing to the fact of fair rental value. They're not citing to a law about fair rental value because it's not. And so the Supreme Court can just simply state that. That's all that it can really state at that point. Number one. Number two, keep in mind that every bond counsel opinion is predicated, that's providing on this is predicated on the certification of that fact by the local agency. So bond counsel's opinion does not cover fair rental value. It's important to keep that in mind. There is a certificate that is executed by every local agency in connection with it saying that the rental payments equal fair rental value. Okay. If the issue were to ultimately be litigated, the litigation of that decision would be made at the trial court, and whatever the trier of fact would be, whether that's a jury or whether that's a judge. Okay. And so at the end of the day, there are obvious tensions with coming up with a fair rental value analysis. Okay. First of all, fair market value of our facilities almost always have to be done on a replacement cost basis, not on an income generation or on a third-party sales basis that is there. And so it has to be done sort of on a probably depreciated replacement cost basis or some sort of basis that basically deals with on that basis. That is a legitimate way of valuing the fair market value of it. Okay. What is really much less clear is how you then break that down on a year-by-year basis, and it come out with the fair rental value. Okay. And the way that practitioners have handled this and the way that local agencies should be approaching this is that what you're really trying to present is not the right answer. You're not trying to come up with what the right absolute answer is on fair rental value. What you're trying to do is present all of the background that the local agency has acted in good faith and in a reasonable way to come to these decisions. And that's why my view of it is like David's view, and I know John's view as well, which is document it, establish it, show what you've done, why you've made the decisions that you've made, so that when if the trier of fact were to come on your transaction, you can establish how you reach the conclusion of fair rental value. I think the biggest thing that I get a little bit concerned about when I'm working on these kinds of transactions is when the local agency signs a certificate, but is under the impression that that was bond counsel's responsibility without really realizing that that certificate certifies that. And then if actually put on the stand, can't explain why they reached the conclusion that they did. And that's what you really want to avoid. I think it is a determination of the local agency. It's not a determination of the outside experts. It's not, and there isn't some absolute answers we've been talking about, but there are good faith, reasonable ways to actually approach the question.
Yeah, and I think that the idea of fair market value assumes that there's a market, which there isn't. And so, it's difficult to sell a jail or a city hall. And so the sort of reasonableness of the approach and just sort of being clear, like we decided to use insured value or replacement value or acquisition value because blank, and sort of having the transaction group be aware of why we chose the approach that we chose and can sort of articulate that clearly if called upon is really the key here. I'd also say that similar to how to establish fair rental value, there's not a lot of guidance about how to abate rent if there's not use and occupancy of the facilities. And I'm not sure that a sort of one size fits all approach is going to work here. And so, I'd ask you both whether you think this is another situation where, what we want to do is make sure that our approach is reasonable. If we ever do face sort of a situation where rent is abated and the local agency doesn't decide to pay the entire lease payment anyway, or whether you think that there's sort of a right answer here.
Well, I'll say that I I don't know of a single instance of abatement. I know of many instances where events occurred where abatement would have been appropriate. The early days, when the leased asset was the building being constructed, buildings not being finished before capitalized interest ran out was extremely common. And I know of during the major earthquakes, there have been public facilities damaged. In all those cases, the government agency basically paid and just paid and didn't want to deal with the market impact of not paying, treating it really like debt rather than abatement. I've been in many conversations where people um, talk with a presumption of how abatement works, especially if the value of the asset is greater than the par amount of the bonds, and then therefore under the presumption that the debt service is below fair rental value. Um, and again, I don't know how you get any guidance on this. I think that's something that, if again, if it never happened, so it's a theoretical problem, but it's kind of like Bigfoot. We can all believe it exists, but nobody's seen it.
Yeah, it's very different than Bigfoot, actually, I would say. But so what I was
Dan,
gonna say is
you've
though
seen
that
Bigfoot, I know. So anyway, go on.
I admit there Bigfoot's real. That's yeah. No, but so what I was gonna say is that John, what you're touching on in terms of this abatement question is one of the larger tensions that I still think remains out there post Ryder. And that is that when you look at the Offner-Dean exception, the concept is that the local agency is entering into a lease that's just like commercial leases, then it's not a debt. Okay. And then what you get is a migration into a legal fiction where you end up with leasebacks that are quite frankly, not like commercial leases at all. They don't have the same purpose, they don't have the same organism and so on. And so one of the tensions that we have is, are we still solving to the four corners of what a commercial lease is going to look like? Or are we solving to this legal fiction that the Supreme Court has created that is based off of these commercial leases, right? And I think, and I don't know if you agree or disagree, John, I still think that there's a difference in practice as to how you kind of go about that question. I for one believe you're solving to the legal fiction. I don't believe you're actually trying to go out there and do some broad-based manner. In which case, if you're solving to the legal fiction, what you want to make sure is that your lease has an abatement provision that is defensible. How you actually do it in on the day won't matter, to be candid with you, because how you do it on the day ultimately doesn't go to the validity of the lease. And what you're really concerned about is the validity of the lease in the outset. And so any sort of a reasonable provision that establishes if we don't use and occupy the premises, then we don't have to pay rent, is going to solve to Ryder and to Offner and Dean just fine.
But the problem
again,
Dan, sorry, go ahead.
yeah, but if you actually were to measure up what we do against other commercial leases, you may find, I mean, commercial leases are going to be potentially more stringent. There are going to be other elements of it that might be there. So it just depends on how you approach it, but that's how I approach it.
Yeah.
But and Dan, the problem really is partial abatement, right? If the building were completely destroyed, we know how it works, how it
Right,
should
right.
work. But it's
Right.
really questioned, well, you lost a third of the building.
Right.
But you're fair, but you could argue that, well, we still have fair rental value capacity is, and how much is, and as you said, it's the provisions in the document. It's not the practical thing because we never had to deal with it. It's what you put in writing at the beginning. And you made me more curious in terms of looking at leases and looking at how abatement is described in the lease, particularly for partial abatement, because that really is the rub.
Right.
And I I mean, I think that the Ryder Court actually says, we don't care if this is a lease. You could call it an installment purchase contract. As long as the payments are contingent on consideration during the period, we're happy. And so, does it look like a lease? Does this look like a commercial lease is a question that comes up still after Ryder, but I'm not sure that it's a question that we need to be asking. And, maybe we can go to the next slide.
Yeah, I agree with you, John.
And so we, post Ryder, I think we've seen a few conventions start to change. And I do think that, the sort of rigid adherence to what a commercial lease would look like has faded. We've seen the industry go from fully funded cash reserves to no reserves at all for highly rated issuers. And then there's this essentiality idea, which again doesn't show up in any of the cases, but which we've spent a lot of time talking about. Um, and that question has really gone away as well. And I know that I've done a number of deals with sort of obviously inessential assets, um, like parks, that the market has been happy to accept. And, I don't know whether you both have had similar experiences, or whether you want to add anything to the list.
Well, the only thing I'd say is that some of these issues are not issues of law, but issues of credit and market acceptance. The reserve fund, for example, was never an issue of law. It was to give comfort to investors that there was a cushion if any of these pinhole risks were to ripen. And essentiality um, is another one of those things that investors, rating agencies, bond insurers, which is often now a missing element of the review and the credit conversation, they thought was important under the notion that a more essential asset is more likely to be paid in the event of abatement because it's just so essential. Everybody's want to keep the thing running. I mean, the irony is the less essential assets are often the most marketable ones. The office building may be viewed as less essential, but you could actually relet that thing, whereas opposed to the police station is absolutely essential, but no remedy that you could use on that. So that's the piece of it. And that voice, we're not really fully addressing that voice. I think the voice of the market concern has gotten quieter. You don't get a lot of feedback anymore. And I think that's because um the market has come to accept these as just a valid form of financing, almost unsecured indebtedness, and let the lawyers deal with the little messy details.
Yeah, and to John's point and to your point, David, I mean, I think the we have seen a progression of lease revenue bond transactions where it is my perception, was not there, David, you were there, but that as these were launching out into the investment community in the 80s and into the 90s, both bond insurers and others, there was this perception that there needed to be all sorts of pulls to deal with the abatement scenario, and that we needed to cover that, very carefully. And you mentioned that that's not a question. We do have a second webinar next week that is actually going to be talking about where is the investment and rating agency community today, and how has that changed from past times. But to John's point, a lot of the lore, the oral tradition that we have inherited was not legal to begin with at all. It never had anything to do with the cases whatsoever. It had to do with this perception that because there was an abatement risk, you needed to have reserve funds, rental interruption insurance, full scale insurance, and it had to be an asset that the city desperately needed to have so that you knew that they would be able to rebuild that facility. Otherwise, the risk of abatement just would be unmanageable from an investor's perspective because you'd have no obligation to pay debt service at that point. And I think that the disappearing conventions that John is alluding to is that risk of whether that was a perception of the working group. I know that bond insurers had very specific requirements that they would go down, but whatever that is, we don't sort of need to live like that in the same way we used to have to live with that if we ever had to live like that. My example of essentiality that I like is the unimproved plot of dirt that was used as the leased asset. That's got to be as unessential as you can get. Of course, not a big abatement risk, but you could have abatement if you have environmental issues. But the point being is that I think that a lot of the perceived boundaries and constraints that we live under was a hybrid of legal issues with some perceived credit demands that would be necessary for that. And that the legal principles have not gone out of style, but a lot of those credit issues have.
Yeah. And I think that, just making sure that we continue to clearly distinguish between the two is going to improve the efficiency of our transactions. Let's go to the next slide. So I wanted to talk a little bit here about, additional bonds and the re-enter and relet remedy. With additional bonds, I think it's helpful to talk about how the value of the asset sort of figures into the fair rental value analysis, and how that's changed sort of post rider. And I guess that, one of the questions that I get asked by clients who have a master lease structure all the time is, can we capture increased value? Can we capture appreciation and issue bonds against that appreciation? And again, the decisions that we have don't talk about this at all. I think pre-rider, there was a rigid adherence to the idea that we needed to have sort of level debt across the lease, and there was an almost allergic reaction to the idea of issuing additional bonds against appreciated value. That seems to be changing now. And I see sort of more openness to issuing additional bonds, taking advantage of appreciated value, and less of a rigid requirement to have level debt service. I don't know if you guys are seeing something similar in the market.
Well, that's an interesting one because I have seen lawyers. I've been in deals where the a partner at a law firm, a big law firm that one of you might actually work for, reach a different conclusion. So this is one of those areas which has been the history of lease financing, right? Where there's not rigid guidance and you try to be reasonable and different people come to different conclusions. This might be the one thing here that I think I don't know what the real answer is here. You're saying that though is to me very interesting and I that's the answer I want. So I'm glad you feel that way.
I mean, technically, it's a fair rental value analysis, and I think there's also, I think what John is saying is right. It's a market. A lot of this is a market question of, if you end up, if the building burns down and you get insurance proceeds, and then the fair market value, the amount of insurance proceeds you're going to get are not going to equal the par amount of the bonds, you're not going to get paid back. Right. And so there's a credit quality of what's there at that point. And that's why there's a crucial element to that. I think that also just people do in their one of the ways that people approach fair rental value is making sure that fair market value is equal to the par amount of the bonds as a proxy to get comfortable with that. So it's sort of a both and. But we've seen loosening of additional bonds and a lot of these different things that John has here. And I think one of the things that I would just make the point that we've talked about before in our preparations for this is that, a lot of lease revenue bond deals were done for many, many years by bond insurers. And we did not have a lot of deals that went out to the pure market until after the bond insurers um, were no longer around. And even then, like there was a sort of a dip of sorts of deals that were done before we kind of got back up and going. And the bond insurers would come along and they had very specific requirements and checklists that they would go down that include a lot of the items that are going on here with John as listing here. And I think one of the points that is important to understand is we have not really fully tested what the market is willing to take and not take on a lot of these issues that John is raising here, as well as many others. That is again a big topic for next week as well.
Yeah, and I think whether we're talking about the re-enter and relet provisions or maybe title insurance provisions, as we test the market to see whether the market's willing to accept deals that don't have these non-legally required but credit sponsored features, the markets seem either to be very accepting of getting rid of them, or maybe they're just not paying attention at all. And I wonder how that sort of adumbrates our responsibility, again, as a community, to police ourselves and try to ensure some minimum credit quality for our deals, in anticipation of the day when, we do something wild and crazy and it blows up, and that prompts the court to change the rules underneath us. I don't know
I
whether
also say that, but I think also, John, that also is the other side of that equation also that we've talked about and we both very strongly believe is that the amalgamation of this history of these deals and the way these things have typically been done can very easily work to disempower the financial decision makers to making good decisions.
Yep.
And I think that what the point of a lot of these things are is that these are decisions for the local agency to make, not for the outside professionals to make. And because of this tradition that's being done, pivoting to saying, hey, here are some, sort of traditional categories of things that we've done. Here's what we know and what we don't know about it, including the risk that at some point we can just put together a structure that's so unreasonable that it starts to create like I think as David very wisely, let's remember the debt limit started by putting bad debt out to investors, and so the whole thing kind of can become this circle. But in the end, it's important to keep in mind it's the local agency that needs to be empowered to make these decisions. And we can't let the lore of the amalgamated history of this disempower the local agencies from making good decisions.
Right. Let's go to the next slide.
Yeah.
So I think that we've talked about most of these, but I did want to hit on title insurance because this is a sort of persistent requirement, again, that doesn't, isn't legally mandated, doesn't come from any of the cases, and is pretty expensive, especially if you're doing sort of large dollar value deals. I'm frankly not sure what we get from the title policy other than the title company, putting together the preliminary title reports, which seem, valuable. But the title insurance policy, I'm not sure has a ton of value, particularly for, assets that had been owned by, the city, county, or school district for a long period of time. I have not tried to go out to the market without title insurance. I don't know if either of you had, but I'm curious on your perspective uh about whether we should sort of investigate whether we need to continue with this given how expensive it is.
John, we're running out of time, but that's a topic that I would love maybe after this we could chat. I mean, the real question is what you're really paying for in title insurance is for the title investigation, somebody you're going through this. And I don't know how you get that done, without a title insurance company. It may be simply finding a title insurance company that we can make realize that they're charging way too much, that they're really not absorbing any risk whatsoever, and that they give some accommodation to local government. Maybe there's even a deeper discount. This would be an interesting little project. Maybe CDIAC wants to sponsor this as a little offline workshop.
Well, and I think that the other point, and this is one of the questions that we have one question, and so we would be remiss if we did not answer it. But rental interruption insurance, but general insurance provisions as a whole. And I think that one of the things that I'm finding with some of my clients is that insurance is running out of control now, and I'm dealing with situations where complete casualty insurance, let alone rental interruption insurance, would dwarf any savings that they would get in the marketplace. And so we are at the point where these need to be culled. And to the question, these are financial decisions. Rental interruption insurance, there is absolutely no legal requirement for rental interruption insurance to be in the lease. It's not a requirement that the courts have laid down. And it's another one of those ways that people manage the whole of abatement. The bond insurers were absolutely insistent on rental interruption insurance of 2 years, and there was really no wiggle room for that for what they were going to do. And the answer to the question is nobody actually knows if you deleted if you deleted rental interruption insurance, what would occur? And the answer is no one knows. No one knows the answer to that question.
Well, and it would be implied self-insurance. You can't explicitly self-insure rental interruption because now you run into another debt limit problem. But it would sell to the market under the presumption that the abatement provisions are there for the lawyers, but are never going to be exercised.
Let's
That it's a risk that they're not going to price out.
yeah.
It's just
Let's go to the next slide. I think this is the last slide, and just talk quickly about the Stockton's parking garage. And to me, the point here is that the remedies that you include in your deal should sort of flow from the asset that you're using. And I think that there may be real benefit to a re-enter and relet remedy when you have something like a parking garage, whereas I'm not sure that there's any benefit to the bondholder for a re-enter and relet remedy for a jail or a city hall. But I will also say that I'm not sure that trustees or bondholders really want to be in the re-enter and relet business at all. And even in Stockton, this sort of got refinanced into parking revenue bonds. But and so I'm sort of would like to ask you, David and Dan, whether you see sort of any benefit to having a re-enter and relet remedy, maybe in a revenue producing asset or anywhere.
My confidence of my opinions of this have been shaken. I thought there was value. Talking to some investors, I thought there was value, but I'm not sure I could measure that value. And I've never, and you've mentioned the only time I know of the remedy being exercised. Um, Dan Deaton has probably worn me down to where I'm getting to think that that's just not a remedy that has any value anymore.
I think that the point I would just simply say, and we've got 2 minutes left, but I just think it is important to understand that we have critical essential assets that are being leased pursuant to these lease revenue bond deals. And I think that if there is a right to relet, and those in bankruptcy or in other situations, those assets can be taken away, or at least use and occupancy can be interfered with, and the local agency have very little ability to do anything about it. Okay. And I think that one of the things to keep in mind here is that, when that day comes, the question is going to be, why did you do it? And I think all that I would just really urge local agencies that they do agree to a right of relet, know why you're doing it. And ask, what benefit am I getting from this? What pricing difference is this? Why is it whatever? I think it's a question that is appropriate to test. And then local agencies need to make the decisions that they believe are appropriate decisions to make, and make those decisions. But my only encouragement is don't carry it forward just because it's been there in other deals.
I think that brings us to the end here. But any closing thoughts from either of you?
I'm picturing Robert Berry having a mini stroke as he tries to gain control over our clock. So I think I'm inclined to let the readers read the summaries and let Robert bring us home.
Yeah, afraid to. I have fear, so I'm gonna pass.
All right. So that's going to bring us to a close. More on these business decisions next week. We'll continue this conversation next week on our second session. First, a huge thank you to Dan Deaton. Dan will be back next week, so we'll have some continuity from this program to the next. Thanks to John Palmer and David Broadsley for sharing your expertise on today's program. And I'd like to quickly draw your attention to a few of our upcoming CDIAC programs. Of course, next week is the risk, realities, and market preferences of lease financing decisions. So make sure you register for that webinar if you haven't already. Just a quick advertisement for our Municipal Debt Essentials program. That's our full 3-day in-person program. Will be held down in San Jose on the issuance and administration of debt. And then it'll be our 25th year pre-conference to the Bond Buyer California Public Finance Conference on October 14th in San Francisco. I'll mention these again next week as well. So full program details as they develop and registration information, of course, will be on CDIAC's website. And I will note that with our Debt Essentials program, if there is some staff that on your team that should be attending that or you think ought to be attending that, we are running a little discounted price here for about another week. So if you are interested, it's a good idea to get that discounted price. So finally, please just spend a few minutes completing our post-program evaluation. Tell us what you think. It's very important to us. Just click on the Slido application, the Q&A application, and go to the polls tab, and that's where you'll get that program evaluation. Your feedback's very helpful to us. On behalf of our presenters today and all of us at CDIAC, including our education team, Amelia Shapiro, Trista Zepeda, and Anna Ramirez, I want to thank you all very much for joining us this morning. We'll see you next week, and have a great day.